the first to know Nsem-Pii TV.
In fact, the Attorney General, Dominic Akrutinga Ayini, said or enter into nolle prosequi in most of these high-ranking corruption-related cases. The anything cry. See, I know I enter into. That is the case, you know. Watching who the free mo. Now, atwaswa na according to Martin Alamisi Ben Kaiser Amidu, Martin Ebika Amidu, formerly, occupied the seat of the Attorney General Pen, a special prosecutor, the office of the special prosecutor, when it was newly created by His Excellency Nana Akufo-Addo Chiremua. His Excellency John Dramani Mahama, the President, Dr. Dominic Akrutinga Ayini, Yawaye Attorney General, Adia Omo Aye, in the case involving Unibank, represented by Dr. Kwabena Dufo and the Republic, you know. In fact, Achille Pefe said they stink of high corruption. They stink of high corruption. Martin Ebika Amidu Chiremua and Amoa Dr. Dominic Akrutinga Ayini and the man penine tuno. Ya Dr. Kwabena Dufo dey and I say abetwa homanum kra kire say ketasese proye kankan e bon wo mu say enyasem ketwa. Now it is a write up. Yeah, Martin Ebika Amidu. In fact, watch a 13-page write up, but my simplify no said ye be etiasie. To make kind na the edisa fata say chiremu ba no ma bomoden na ma chiremu. And this is the introduction to this wonderful write up by Martin Ebika Amidu. Also the decision of the John Dramani Mahama government to abort many criminal trials by the entry of a nolle prosequi, and especially in the pending case of the Republic versus Kwabena Dufo and 7 others, as a result of a negotiated settlement with the accused persons to recover only 60% of the proceeds of the financial crimes committed by the accused persons instead of submitting the settlement agreement to the trial court to be recorded and accepted as part of a plea bargaining agreement pursuant to the Criminal and Other Offences Procedure Amendment Act 2020, Act 1079, or asking the accused to make an offer of compensation or restitution under Section 35 of the Court Act 1993, Act 459, as amended to the court. Risks of high corruption. This wreaking high corruption practice by this government has been dressed in the robe of an exercise of prosecutorial discretion by the Attorney General Dominic Akrutinga Ayini, whose discretion needs no explanation, but who, in the spirit of accountability and transparency, considers it appropriate to provide the public with a rationale behind this decision. Now, the truth of the matter is that the government and its Attorney General knew that there was no way they could get away with quietly filing a discontinuance of the trial as they've been doing in such an important and high-profile expropriation of public funds by the government's associates and cronies, without the discontinuance becoming public and patriotic constitutional advocates asking for answers for such flagrant abuse of power and the warm embracing of corruption. What the government has done through its Attorney General is to sidestep the elaborate procedure set forth under the plea bargaining law and procedure contained in the Criminal and Other Offences Act, Amendment Act 2022, Act 1079, Section 35 of the Court Act, which would have ensured a transparent judicial accountability by the accused persons for the crimes committed against the public. Instead, the government and the Attorney General claimed to have used non-legally binding rules and procedures justified on the basis that, in pursuit of this objective, the Office of the Attorney General, in collaboration with other relevant state agencies, established a threshold of 60% recovery of the alleged losses to the state as a condition for reconsidering prosecution in specific cases. First and foremost, the gratuitous government justification delivered under the small screen of reasons by the Attorney General for the exercise of his prosecutorial discretion in a press release from the Office of the Attorney General dated 22nd of July 2025 consists of empty rhetoric of accountability and transparency in the exercise of discretionary power, directly and patently contrary to the preambular values of true accountability and transparency underpinning the 1992 Constitution. Wow. Martin Ebi Kamidu, Brofaka said the Winim Yusu papa. Some of the suspects in the case, particularly the first accused and the recently appointed governor of the Bank of Ghana, who was also an accused person in the same case, when Dominic Ayine appeared as the lawyer for Kwabena Duffuor, have been very close political associates of President John Mahama and the Attorney General Dominic Ayine for years, and it is a statement of fact. Kwabena Duffuor was the Minister of Finance when John Mahama was the Vice President and later became President after the demise of President Mills between 7 January 2009 to 7 January 2009, to 7 January 2013. Kwabena Duffuor also contested the primaries to be nominated as presidential candidate for the NDC in the 2024 election, only to drop out of the race before the ballot. Johnson Pandit Esiama, who is recently the governor of the Bank of Ghana and was recently appointed by President Mahama, was appointed on 16th April 2016 as the second deputy governor of the Bank of Ghana in the first government of the president. Johnson Esiama resigned his office in 2017 to put himself upon the Republic for trial in the case under discussion. Dominic Ayine was then Deputy Minister for Justice at the time of Esiama's appointment to the Bank of Ghana. The case against Esiama in the Kwabena Duffuor case was withdrawn from the trial High Court upon the instruction of Dominic Ayine as John Mahama's Attorney General by a notice of withdrawal filed on the 29th of January 2025 to pave the way for his appointment as the governor of the Bank of Ghana by President Mahama on 31st January 2025. Only to be followed closely by the abuse of power in discontinuing the whole case of Kwabena Duffuor and his cohort of accused persons by nolle prosequi on 22nd July 2025. The foregoing demonstrates that the government represented by the President, John Dramani Mahama, is tainted by conflict of interest under Article 286, with the Attorney General being further tainted with abuse of discretionary power under Article 296 of the 1992 Constitution in entering a nolle prosequi in the case of the Republic versus Kwabena Duffuor and 7 others on the grounds of a shadow self-serving established 60% threshold for the recovery of the alleged losses to the state as a condition for reconsidering prosecution in specific cases. Instead of using the plea bargaining or offer of compensation or restitution laws to ensure accountability, transparency, and compliance with the due process of law in the pending criminal trial. John Dramani Mahama and his Attorney General exhibited the worst dishonorable reputational trial of an Attorney General in taking the electorate and Ghanaians for granted and for fools by not acknowledging and explaining the ethical fact that he, Dominic Ayini, was the lawyer for Kwabena Dufo and his HODA Holdings Limited in the Republic versus Kwabena Dufo and 7 others before he was appointed as Attorney General to underscore his ability to act impartially. Nonetheless, in the exercise of the prosecutorial discretion to enter the nolle prosequi. This failure constitutes the worst example of misconduct any Attorney General can set for the legal profession as the leader of the bar. The palpable and deliberate omission by Dominic Aklutinga Ayini tainted the entire press briefing and rendered in lies and dishonesty. The public was, as a matter of right, entitled to be informed by the Attorney General that the lawyers for the Unibank directors and shareholders who approached him with a proposal for their client's intention to settle their indebtedness to Unibank in March this year, after he had metamorphosed from one of Kwabena Dufour's former lawyers to Attorney General, were former colleagues in the case he had shared perspectives with as to the strength and weaknesses of the case in his former capacity. And Nsem-Pii yewura Martin ebi ka medu kan nyina ne se saa di no a Dr. Dominic Aklutinga Ayini ene Dr. Kwabena Dufo ene the other accused persons ko ye ya wo so mutua 60% no. According to Dominic Aklutinga Ayini, kwan of asoro kwanya amra so because emra ye wo plea bargaining ye wo we ya ni nyina no ewura case ni ma ye di case no magana fo nyina hu se ye di case na ma na dru empempenso say the accused persons are Jomo Bonyomo ye Yoroma Giatum, so they are entering for a plea bargaining procedure or any other procedures. But where they be a sense that Dominic ABK Amidu, Martin ABK Amidu said the any yana say Dr. Dominic Ayini, press conference for ye, the any decaying was so catch a gun for Emma Ghana for in a tell say. Nippon war Jano no so could 60%. Case in a buyer, men and I'm a lawyer, and a lady, Baba Attorney General. Naka Ghana for you know who baby Uja. And we know what we say. All the accused persons in that case, including the governor of the Bank of Ghana, it is a basic fact to say, Omunina, Namfo, with His Excellency John Dramani Mahama. And we teach a conflict of interest. Conflict of interest, Kasibian ho, change Yakosui. Now, Dr. Dominic Ayini, well, good in one more, Papa. Near Cassette, Attorney General be a good in one more, in this republic, Dr. Dominic Ayini. Now, one can't crown find Ghana for. Yantuaso. The meeting Dominic Ayini conveyed on the 25th of March 2025 as Attorney General was clearly tainted with this conflict of interest and bias on his part. And this would not have been lost on the receiver of Unibank, Mr. Ni Amano Dodo, who could not have dared to protest in the changed circumstances of Dominic Ayini from Kwabena Dufour's lawyer to Attorney General. The reader should not also forget the fact of the new governor of the Bank of Ghana's relationship with the case as a just freed accused person that enabled him to be appointed to that position. What comes out of unmistakable to me in the 7-page brief was that Dominic Ayini, Kwabena Dufour's previous lawyer, was negotiating with Dominic Ayini, the Attorney General. Wow! According to Martin Nsem-Pii, negotiation course now Dominic Ayini versus Dominic Ayini, because as at the time the negotiation was ongoing, according to Martin Nsem-Pii, Dr. Dominic Ayini was still the lead counsel for Dr. Kwabena Dufour in the company. And on one side, Attorney General, and on one negotiating with on one home. Say, Nipa no ya accused no to 60% of Sika wajidie flow man. This is according to Martin Nsem-Pii. The Dominic Ayini negotiating with Dominic Ayini. Dominic Ayini, as Kwabena Dufour's previous lawyer, negotiating with Dominic Ayini as the Attorney General in the same case. And now no Dominic Ayini defending Dr. Kwabena Dufour. Very, very interesting analysis from Martin Alamisi Ben Kaiser Amidu. Also, Dominic Ayini, the Attorney General brief to the public, recognizes that apart from the criminal case against Kwabena Dufour and his cohort of accused persons involving a total amount of 1.2 billion cedis, there was also a pending in court a civil case involving a total exposure of 5.7 billion cedis. It's what they want to Ghana for the cases no yemienu. Criminal case na 1.2 billion cedis. Near was civil cases so anso 5.7 billion cedis. O de ka ho 6.9 billion Ghana cedis was at stake. Niamu say amu sika do sen and a Dr. Kwabena Dufour tua. Until the 60% was worked on the 1.2 billion cedis, but 5.7 billion cedis a year civil case in there. Dr. Dominic Ayini can was. This according to Martin A.B.K. Amidu. Dominic Ayini, Kwabena Dufour's defense lawyer, cannot, as Dominic Ayini, the Attorney General, take an independent and impartial, pragmatic, holistic approach by engaging both the receiver and the accused persons, same of whom he previously represented, to broker a resolution that settles both the criminal and civil dimensions of the matter. The Attorney General's statement that the terms of the settlement are structured to ensure that the Attorney General, the Bank of Ghana, and the Ministry of Finance exercise oversight over the recovery of the negotiated amount without any undertaking in the nature of evidence that the terms of the agreed settlement have been filed and accepted as a consent judgment by court in the civil action is bogus, fraudulent, and corrupt. Publish the entire settlement agreement and let Ghanaians do the math and reasoning for themselves. Ghanaians are no fools. The concluding statement by the Attorney General in the same paragraph that progress under the agreement will be subject to quarterly reviews to ensure that the accused persons fulfill their obligations as agreed is an insinuation that the settlement agreement between the government and the accused persons is a private settlement arrangement and not one cognizable by the court as an enforceable consent judgment in the civil suit. How can a conflicted Attorney General, a conflicted Governor of the Bank of Ghana, and this corrupt government personified by the President enforce the alleged settlement agreement, which from the foregoing has no binding force as a consent judgment? Wool is being pulled over our eyes. It is important to highlight the fact that the Attorney General's press release of 22nd July 2025 does not even mention the pending civil case involving 5.7 billion cedis as part of the reason for entering the nolle prosequi. The reason was entirely based on a minimum threshold of 60% for the recovery of assets as a condition for the filing of the nolle prosequi. The integration of the 1.2 billion cedis in the criminal charges with the total exposure of 5.7 billion cedis in the civil case in a brief on 22nd July 2025 was an afterthought intended to bewilder, jade, and confuse the public, especially the vulnerable Ghanaians. The purpose of criminal justice is principally for holding persons suspected of the commission of criminal offenses accountable for their crimes by convicting and punishing them for the offenses to deter others from following the same criminal path. In pursuing this laudable objective, the administration of criminal justice would rather that 9 guilty persons be set free than 1 innocent person be convicted. Consequently, the inability of the prosecution to secure a conviction in cases it has prosecuted to judgment is no justification to compel or intimidate accused persons to agree to payment of a percentage of alleged financial crime as compensation or restitution or recovery outside Section 35 of the Court Act 1993, Act 459, or the plea bargaining law encompassed in Criminal and Other Offences Procedure Amendment Act 2022, Act 1079. The example of the subsequent acquittal of Michael Nyineku in the Bed Capital case, cited by the Attorney General for earlier entering the nolle prosequi in former client Kwabena Dufour's case, is disingenuous. The acquittal of the accused by the Court of Appeal on 24 July 2025, subsequent to the nolle prosequi entered on 22nd of July 2025, does not foreclose the state to pursue its right of appeal to the Supreme Court and also in civil action for the recovery of the total amount involved, except in cases where conflicted Attorney General in the mode of Dominic Ayini and their corrupt government decide to protect family, protect friends, protect cronies, and party faithfuls in financial crimes. Let us put Ghana first. I have spoken up. What of you, fellow citizen? Stop playing tricks with the intellect of the electorate with cheap psychological media operations in the name of being accountable and transparent. Meanwhile, you are sinking and stinking in high corruption. Martin Alamisi Ben Kaiser Amidu. Signed 29th of July 2025. This is a masterpiece of an expose. And Martin Amidu, former Attorney General, former Special Prosecutor, Diabetuga, Secretary Shepherd Kankan Padi, Abayi, any because Yipa. Thanks to Dr. Dominic Kutinga Yini and His Excellency John Dramani Mahama.